Again, I'm Beth Goodell from Community Legal Services in Philadelphia. And this morning we have Eileen Yakton from Neighborhood Legal Services in Pittsburgh, and Peter Schneider, also from Community Legal Services in Philadelphia. The title of this hour session is Litigation Issues, which, since this is a conference for lawyers, really could have been the whole conference. But this session on foreclosure is funded by NeighborWorks. NeighborWorks doesn't do litigation. So out of the 7 hours that we had, we were committed to doing 6 hours under the NeighborWorks funding, which left us with 1 hour to address litigation-specific issues. But much of what we talked about yesterday is relevant in litigation, so I think it's all good, but we do have 1 hour to be litigation-specific. We have a couple of issues that we wanted to make sure we discussed, including more of a discussion about HAMP issues. We talked a lot about HAMP yesterday, and for those of you who weren't here, we're not going to be able to go back over just the basics of HAMP. But if you have your materials from yesterday, there was a handout that included litigation issues under HAMP, so we're going to maybe make some reference to that. But we'd also like to open this session up to questions or discussion from those of you who are litigating foreclosure cases. And we're going to do that with the first 10 minutes or so. If there are a lot of questions, we'll go on with them for a bit longer. But as I see it, we have 3 more hours of foreclosure. We have 1 hour that we can specifically talk about litigation. If we want to take up half of this hour talking about your questions and having you share your experiences in litigation and kind of brainstorming, that would be great from our point of view. We'll pick up on the other material in the last 2 hours. So sort of open mic on litigation issues for the first part of this hour. Then we'll talk specifically about HAMP litigation issues, and then about who owns the loan, which is an issue that those of us who routinely litigate foreclosure cases are thinking about a lot these days. And then for the next 2 hours, we have some other issues that we'll talk about. So litigation questions, comments, sharing of what's going on in your cases now. Don't be shy. If you're doing this work in your day-to-day life, there must be some things that you're encountering that you might want to share with others. Yay! There we go. Get us started.
In a where you find that the mortgage loan is VA approved, what effort does the lender or servicer have to make to apprise the homeowner of forbearance or mitigation options before going to filing a complaint?
Okay, and you mean VA insured, I'm assuming, that there's a...
Yes.
Okay.
Yes.
I've never dealt with a VA insured loan. I think some people in this room have, and it might go way back to the last time that some of us have dealt with a VA insured loan. But Peter was nodding his head a bit.
Well, I haven't dealt with a VA insured loan either. I don't know why, but for some reason they don't come up. But FHA and VA all share very similar characteristics, and I think the basic approaches are the same. There's a requirement, at least I'll speak under FHA, and hopefully what I say about FHA will be correct under VA. If I'm not, then nobody's addressed your question. But FHA is required to do loss mitigation on their loans. They're required to offer a package of, or the opportunity to apply for a package of loss mitigation opportunities. They're required to send to the homeowner or inform the homeowner that they're able to apply for these opportunities, and they're actually, if the homeowner is within, if the servicer is within, or the lender is within 200 miles of the home, they're required to have a face-to-face meeting with the homeowner. This is FHA. I'm not sure that this applies to VA. Before they can commence foreclosure. I've never in my lifetime heard of that face-to-face meeting ever happening, but it's very clear. The requirements are found for FHA in federal regs, in the Code of Federal Regulations. governing servicing of FHA loans, and they're also found in a variety of HUD handbooks and letters that can be found on the web on something called HUD Clips, HUDCLIPS, which is a part of the HUD website that has various HUD publications. And you used to have these enormous binders in your office with all of the different handbooks and updates and whatever. Now you can get them on the web if you only know where to find them. And
Does anybody in the room have more recent experience with the VA? Like, where do you go to find similar rules for VA loans?
Well, I would just want to say that I would be, what Peter is saying is that then you can, as a defense, argue that the mortgage lender's failure to comply with those regulations is a defense. And we would be very remiss if it was not noted that one of the veteran lawyers of Pittsburgh Legal Services in the case called Cobb versus something or other, or somebody versus Cobb, argued and won on the issue that the guidelines, which are in the VA handbook, it's not by regulations, but VA handbook, also provide for an affirmative defense if the VA has failed to do those things. So there's a Superior Court decision that's been around for 20 years now that does mandate, well, not mandate, but it does say that the failure to comply with those VA guidelines in the handbook could constitute an affirmative defense to a foreclosure.
it's an equitable defense, and it can get you past summary judgment to the point of having to, I guess that would then be up to the judge to determine whether the failure to do these things or whatever it was they failed to do rise to the level of significant enough that the foreclosure should be barred. We typically plead these in preliminary, we do that
In a new matter
to raise the issue. It's interesting that for FHA at least, it used to be there was no, it wasn't clear what the homeowner's rights were. These were servicing requirements that the FHA applied to the servicer and required the servicer to follow. That's, I think, where this great equitable defense argument came up. At some point, FHA started writing the requirements into the mortgage itself. And the mortgage says that the lender is not allowed to accelerate the obligation or foreclose before it takes all the steps that are required by the guidelines. So you can plead it as a failure to comply with the condition preceding to filing the foreclosure also. And we tend to plead it both ways.
Yeah, and it's paragraph 9 in the more recent FHA insured mortgages, where it incorporates, as Peter said, into the mortgage contract that you have to comply, the servicer has to comply with the FHA regulations. I'm sorry that this discussion has been more about FHA than VA, but as a legal matter, the right to those servicing provisions is similar. And there is, in addition to the Cobb case, which I don't have the cite for, but I do have the cite for the same principle for an FHA loan. It's Retirement Fund, Commonwealth of PA School Employees Retirement Fund versus Terrell. The cite 582 A 2nd 367, and that's a Pennsylvania Superior Court decision. Again, 582 A 2nd 367. That case is cited in your HAMP materials from yesterday, page 7 of the HAMP handout. We cite it there for the proposition that the HAMP guidelines, failure to comply with the HAMP program, should be an equitable defense to foreclosure along the same vein as the FHA and VA guidelines. And in dealing with the servicer, as opposed to filing the foreclosure defense, just cite these cases to the servicer. It will mean nothing to them, but maybe pre-foreclosure, maybe they'll get it to their lawyers. I do find that once we filed an answer to the foreclosure raising these issues, they do pause. That they won't file a summary judgment motion immediately. The lawyer for the mortgage company will then try to get the servicing, get through to their client to get the servicing done properly. And at that point, you may be fighting about foreclosure fees and costs. If your position is this foreclosure never should have been filed because you didn't go through the FHA or VA servicing, or you didn't honor the person's request for a HAMP modification, that you're now trying to get rid of the fees and costs, which is a different fight, which may be harder than stopping the foreclosure altogether.
Unfortunately, the actual loss mitigation options aren't the greatest. And one of the hardest features of them is that they're not available to people who are more than 12 months in arrears. So sometimes it's almost better if they don't comply with the requirements and you get a defense, and at least you then have the ability to try to negotiate over a solution. If they actually had offered the options or had considered the person, and they might have properly rejected them.
So I haven't seen anything about VA HAMP. I don't know off the top of my head if a VA insured loan is eligible for modification under HAMP. So I'm sure working these cases out there, and if this issue comes up, let us know what you find out. There was this specific FHA HAMP product. I don't know if there would have to be a VA specific HAMP product in order for that, for those loans to be covered. Go ahead.
Do you have any further reading recommendations? So like when we leave today, what materials or websites do you like to refer to keep up to date with mortgage foreclosure issues, or what original source materials did you use to bring yourself up to the level where you are now in terms of your knowledge?
There is and I hesitate to recommend this because you will get the volume of email that you will curse me for. There's a national level organization called the National Association of Consumer Advocates, or NACA, National Association of Consumer Advocates. Once you join, and NACA covers the full range of consumer issues. Mortgage issues are very big for them right now, but they also cover debt collection, auto loans, you name a consumer issue, they're involved in it. Once you join, you can join their mortgage listserv, and you get a very high volume of emails, maybe 10% of which are really, really important for understanding what's going on in this field. And you can sift through them and pull out that 10% and really keep up to date on what's going on. There's a Pennsylvania specific, and I think, do you have to join NACA nationally in order to be on the PA NACA listserv?
Because somehow I got on.
Okay, so, well, then Eileen is.
I'm on, and I never joined.
So there's a Pennsylvania NACA listserv, and I'm forgetting who the contact is, who runs.
Joe Goldberg.
Goldberg. Joe Goldberg, a local lawyer. I don't have the email site off the top of my head, or how you get in touch with Joe to get on that listserv. That's a smaller volume. Actually, Don, do you know how to contact? Because Don,
right off the top of my head, I don't, but I can tell you.
Don Merritt's in the back of the room, I think, is the source of maybe 50% of the emails on the Pennsylvania NACA listserv, and he tends to transfer information that came from in a way that's appropriate, because you can't just share emails from these listservs with people who aren't members, but he gets the information and shares it, and so getting on Don's email list is a really good way of staying in touch with these issues without getting the huge volume that comes from the NACA.
Well, and actually, a lot of the stuff is cross-posted from the Pennsylvania NACA list and the consumer list of Pennsylvania Legal Services
Right,
of plan. So that's also a good source of information.
And also our very own Legal Services
Right.
National Consumer Law Center has the best probably the best publications ever about these issues, and so.
So the National Consumer Law Center, or NCLC, puts out publications that once your office has purchased a set, they get annual updates, and I'm not sure what the costs are. Our office subscribes. I'm not sure if the cost is prohibitive.
I thought they were free to legal services.
No.
Is that
Not
not
anymore.
true?
Yeah.
Okay.
Discounted.
Yeah.
But
They're
and
terrific.
They are terrific for general consumer practice as well as foreclosure specific. They have volumes specifically on predatory lending, foreclosure defense, foreclosure rescue scams, truth in lending. It's a really great set of books if your office can spring for them. The NCLC is having its annual conference in Philadelphia this year, and this is something that I wanted to mention, so thank you for your question that prompted it. It's as close as it ever gets to folks in other parts of Pennsylvania. I don't know if they're going to be in Pittsburgh anytime soon. But if your office can afford to send you to the conference, there's a discounted rate for legal services attorneys. The deadline for scholarships has passed, but if you can get to Philadelphia, it's at the end of October. There's a lot of sessions on foreclosure, on truth in lending. We're going to talk really briefly about truth in lending. It's not something that you can cover in part of a 1-hour session, but there'll be several sessions on Truth in Lending Act. That's pretty important for foreclosure defense work. So if you can get to Philadelphia in late October for the NCLC conference, that's a really good way to get updates on what's going on now. Yeah.
I think that the smallest helpful book is the Stop Predatory Lending book that NCLC puts out, because it's less frightening. You know, it's more like a paperback book size, and it's very good. It has lots of details, very helpful, very specific. It can walk you through, and so I think that's a good place to start for people. So, and I don't know if your office already has it, but if you don't, it's well worth buying.
There's also a volume specific to Pennsylvania consumer law, edited by Carolyn Carter, who's one of our great stars in consumer law in Pennsylvania. That's a treatise that most law libraries would have if your own legal services office doesn't. Again, it's consumer law in Pennsylvania, Carolyn Carter. It has a chapter on foreclosure that's updated every year by some of the folks in Pennsylvania who specialize in foreclosure defense. So that's another really good volume to look at. Most of us who practice foreclosure defense and legal services are doing other types of consumer law as well and other types of issues. So that's a good book for the other consumer issues as well. Irv Acklesberg, who up until a couple years ago was a long-term legal services lawyer at CLS in Philadelphia, has a volume out that was through PBI, the Pennsylvania Bar Institute, for a training that he was doing with other lawyers across the state. You can get that volume from PBI, and it's a good standalone introduction to what's going on in mortgage lending and foreclosure defense. I forget the name of the session. I think it was Saving the Family Home. So if you go to PBI's website and maybe type in Saving the Family Home, that training will come up, and then you could purchase the book separately.
Isn't he working on a book? I don't know when that's coming
He
out.
is working on a book that I think that material was a feed-in for, but so you can get it probably, I don't know if it'll be cheaper through PBI. There's new information, like the HAMP program, this changes monthly. So it's important to find sources of information that will update you routinely. And for that, these listservs, and again, I would talk with Don about how to get on the Pennsylvania-specific lists.
And you can ask the Pennsylvania list. I mean, people are asking questions all the time of each other. It's not just reading what other people say. And if you have a question that comes up in your caseload, ask it, and you're going to get answers.
Yeah, the listservs are really important for keeping up to the minute on what's going on in these cases. Thank you for your question. That was fertile. Any others? In which case, if we could turn back to HAMP for a few minutes. If you brought your materials from yesterday, if you look at page, the page that's numbered as 7, the HAMP materials were early on in the materials from yesterday. How many people do not have their materials from yesterday with them? Some, but some do. So maybe you could share with each other. If you start at page 7, portion of that handout that's titled HAMP Select Legal Issues. And if this spurs some of you to ask questions about other legal issues, please do. This was, I summarized this. One of my colleagues said we should entitle this the top 10 reasons that mortgage servicers will tell you they can't do a HAMP modification. But there are more than 10 of them, and there are now, more have come to my attention since summarizing the ones that had come to my attention when I wrote this. By the way, when you run into situations where a servicer is telling you no, when you think your client ought to be eligible for HAMP, it's important for us to be reporting those situations. Even though it may seem like it's falling on deaf ears, it's important for us to be reporting those situations. And point number 1 on this HAMP handout is where you can email to make a complaint. support@hampadmin.gov. Freddie Mac has been assigned the role of enforcement of HAMP. And my understanding is that there are a couple of people there to deal with the nationwide situation of compliance with HAMP. So your specific complaint is not necessarily going to get lightning fast response when you email it in. But there are people who are keeping track both of the general problems and the servicer-specific problems. So it's important that you identify the servicer, identify the loan number, and describe the problem. Because as problems that keep recurring with specific servicers come up, eventually somebody does something about it. I have found that eventually somebody at Freddie Mac or Treasury will get on the case of Saxon Mortgage or Chase or Citi for repeatedly making the same mistake in their operation of HAMP. So send the emails. Eventually it will make a difference. There are hearings going on this week, going on tomorrow in Philadelphia. The group of people who are supposed to be enforcing HAMP coming to Philadelphia to hear testimony from legal services lawyers, housing counselors about what's working and what's not working. So we've been trying to pull together stories and looking for patterns of the various servicers to report. So there is an attempt being made to see what's not working and to fix it. As we discussed yesterday, there are these different sources for HAMP. It starts out with the Treasury Department creating this program, getting servicers to sign on to these contracts, which bind the servicers to the program guidelines and the supplemental directives. These supplemental directives come out every so often. The first one is the most general, but there have been others, including the ones that created the FHA HAMP program and the second mortgage HAMP program. So you can find those all online. The section from the contracts that binds the servicers to the directives and the subsequent sources of information that come out is quoted on page 7. Point 2, it's the actual section from the contracts that binds the servicers to following supplemental directives and other materials. Point 3 is the citation to this case that we just mentioned that makes the FHA servicing requirements a foreclosure defense in Pennsylvania. You can cite that case for the proposition that foreclosure should not be allowed to proceed if someone has requested consideration for HAMP. We discussed yesterday that the guidelines and directives are not clear enough about stopping foreclosure before there's a sheriff's sale scheduled. It's clear that a sheriff's sale shouldn't proceed. A servicer should not proceed with a sheriff's sale if someone has asked for consideration for HAMP, but it seems that right up to the point of conducting the sheriff's sale, there's wiggle room. So what we're doing is we're filing answers that say you should not allow the servicer to proceed with foreclosure because we've requested consideration under HAMP. Now, I've just received my first summary judgment motion having raised that. I haven't even read the motion yet, so I don't know what they're saying, but I expect them to say, oh, it's optional up until the point of a sheriff's sale being scheduled. So we should be allowed to take judgment, schedule the sheriff's sale, and then if we've approved the person for HAMP, then we'll cancel the sheriff's sale. And my response is going to be, well, that's completely wasteful. You know, that you're gonna charge my client with the fees for scheduling the sheriff's sale, and then the practice has been, my experience has been, that up until the date of sheriff's sale, I might not hear back from them. And that if I get to that day before the sheriff's sale, I'm gonna have to go in with an emergency petition to stop the sale. So I'm gonna ask the court to deny summary judgment, because there's no point to it, as long as I'm waiting to hear. Maybe if they've denied me for HAMP and provided me with the reasons in writing why they're denying my client for HAMP, and those reasons can't be contested, well, then maybe it's appropriate for summary judgment. But before that point, the court should deny summary judgment.
I just interject, in an analogous situation, I actually have one on a summary judgment motion, and that's when, as you know, if we file, as long as an Act 91 application or for a period of time is pending, then the courts are, then there's no legal right to proceed with the foreclosure action. But once an administrative decision has been made, not the grievance hearing, but once the administrative decision has been made by PHFA to deny Act 91, then the mortgage company can file a foreclosure action. And in the past, and then when I file an appeal from the Act 91 denial, that goes forward, but in the meantime, the lender can proceed with a foreclosure action. I have filed, and as an affirmative defense in the past, I call it equitable stay. Petition for equitable stay is an affirmative answer. And I've said, please, court, don't continue with the foreclosure case, because the appeal hearing is still going on, the appeal proceedings. And the courts have, in my experience, at least one court, my court, denied the right of they stayed the right of the foreclosure lender to proceed while we were waiting for the appeal. So I think you could think of it in both ways.
Yep, and you know, Eileen was just referring to Act 91, the statute that created the HEMAP program, which we discussed a bit yesterday. So do we need to talk a little bit about what Act 91, because this is another litigation issue. I know I'm jumping a little bit outside of the HAMP topic, but it is very similar, because there's a point where maybe your client didn't timely apply within that 30-day period that Act 91 gives you before foreclosure can start. And is everybody familiar enough with those requirements under Act 91? Should we spend a little bit of time or no? Part of the handout for this session is a summary of a very brief outline of Pennsylvania foreclosure law. It includes references to Act 6 and Act 91. So if you kind of dig into your materials for today, past the materials concerning who owns the loan, to a handout called Foreclosure Defense in Pennsylvania. It's separately numbered. It starts with page 1 after you get past the unnumbered foreclosure, who owns the loan material. And then on pages 5, 6, 7 of that material, Act 6 and 8, Act 6, Act 91 are outlined. So, but basically, Act 91 requires the sending of a notice that informs the homeowner of the possibility of getting HEMAP assistance, and requires, Act 6 does a similar stay of foreclosure without the HEMAP information. But you get 30 days, as Jennifer said yesterday, now 33 days from the date you get that notice, from the date on the notice, I'm sorry,
The date of mailing.
on the date of mailing, thank you, the date of mailing, to go see a housing counselor and then subsequently apply for HEMAP. So you get this stay of foreclosure. Well, let's say your homeowner client didn't get into a counselor, didn't apply for HEMAP, within that time frame, comes to you with a foreclosure complaint, no judgment yet. The Act 91 notice or Act 6 notice should be attached to that complaint. The homeowner can still apply, but now you've got a live foreclosure action. You can file an answer to that action, as Eileen said, raising the fact that the homeowner has now applied for HEMAP assistance, and no judgment should be entered pending the decision on that application for assistance. Or, as Eileen said, you could also file a request for a stay of the proceeding, and I don't know if you would do that in addition to having filed the answer, But I think once you file the answer, as a practical matter, the foreclosure is not going to proceed until you've heard back about the HEMAP, of the award or denial of HEMAP assistance. As a practical matter, by the time the other side gets the summary judgment motion written and filed, you're probably going to have the 30 to 60 days that it takes PHFA to decide on the HEMAP application. But it's important to stop a judgment from being entered, because again, once a judgment is entered, your client faces the sheriff's sale, and trying to get the sale stayed while you're waiting for HEMAP is harder than just flat out filing in the answer and slowing the foreclosure down. It's a colorable defense as an equitable defense. You're not doing anything in violation of the professional rules of conduct, because you're asking the court to wait to see if the person gets HEMAP assistance, to not incur the additional expenses that are involved with the scheduling of a sheriff's sale. So circling around back to HAMP, same kind of issue, file the answer that raises HAMP as an equitable defense to the foreclosure.
So two ways to raise it, I guess. Just one is to halt the foreclosure while the client is being considered for HAMP. The other is if the lender has not complied with HAMP requirements, allege that as a defense as well.
Right, so not just that, so now your client has requested HAMP consideration, so don't allow the foreclosure to proceed. But also, my client applied and was turned down wrongfully, which is an even stronger defense at that point. And
then do discovery as to what the process was by which they considered your client for HAMP, so that you can actually determine whether they did or did not follow the requirements.
As a point of strategy and pleading, is there a way to raise HAMP concerns and preliminary objections?
I've thought about that a bit. I think because it's not a clear requirement of Pennsylvania law that you have to do this before filing a foreclosure, that I'm not sure that I would go through the PO process to try to raise it.
Well, maybe not by itself, but there's so many unverified complaints coming by. You can join that with something such as plaintiff has failed to allege compliance with HAMP requirements.
You could try it. If I get the right, and please let us know what happens, because it's in Philadelphia, the POs, the motion to decide POs would go through our motions court, which is limited to just a couple of judges, one of whom always rules against us. And I'm not sure, no matter what it is, and I'm not sure that I would try this if I knew he was going to decide the PO motion. But I would love to hear if it works for anybody, because it is now. And the other thing is that it depends on the status of your client's situation at the time that the foreclosure is filed. Because of the phrasing in the HAMP guidelines and directives, again, what's clear is that you can't proceed with a sheriff's sale. It's also clear that if your client has requested HAMP, I think that it's clear that they're not supposed to file a new foreclosure. So if you have proof, including, I think, your client's testimony that they made a phone call, because as we discussed yesterday, making the phone call to ask for HAMP consideration is the official start of the process. So if your client can put into an affidavit that I called and requested HAMP, and they started the foreclosure after that might allow you to get, but see, that is going outside of the record, isn't it?
Actually,
So-
litigation issue, you are allowed to raise matters outside the record, and they're called preliminary, well, I can't remember now, preliminary objections. There's something in the rules that says you are allowed to, in the nature of outside evidence or something like that, and you are allowed to plead that, and then the rules actually allow even more time to respond to that, and it does require an evidentiary hearing. They're in the rules right after preliminary objections,
So you could attach an affidavit from your client saying, I made this phone call, so I'm in the HAMP hopper, and they then filed the foreclosure, and that you might win on getting the foreclosure complaint dismissed.
One thing is that in addition to the HAMP program, which pertains to those mortgages which are not I don't know the proper term. Oh, they're not administered or whatever by Freddie Mac or Fannie Mae. There are requirements that the Freddie Mac and Fannie Mae mortgages also comply with analogous rules concerning review for these loan modifications. And those are even stronger. Actually, yes, about a year ago, Dan Sullivan and Greg Simmons, the people who were here last year, were talking about how there were about 70%, they said 70% of mortgages in this country are Freddie Mac or Fannie Mae, what is the term? Administered?
Owned.
About what?
Owned.
Owned, okay. So there are two websites to go to. There's a Freddie Mac and a Fannie Mae website you can go to punch in your client's address, because there's nowhere on the documents that would show whether or not those are Fannie Mae or Freddie Mac owned. And punch in your address and see whether or not they are. But I've never had a client whose address is on those comes up, so I don't really know how to find that out.
Fannie Mae and Freddie Mac generally loaned prime loans. So most homeowners whose loans are owned by Fannie and Freddie are decent loans that may now be going into foreclosure at higher rates because unemployment is increasing. But the subprime lenders, those loans are generally not owned by Fannie Mae and Freddie Mac. They are securitized outside of Fannie Mae and Freddie Mac, and they're owned by trustees. And their rate of foreclosure is so much higher than prime loans that our clients who are in foreclosure may more often, who are in foreclosure because their loans were bad as opposed to they lost their job recently, are more likely to be owned not by Fannie Mae or Freddie Mac, but by some other securitization trust.
Maybe this is a good segue into who owns the loan.
Yeah, there are a couple of other points. What time is it, by the way?
It's
We
too
have
late.
15 minutes left.
Okay, all right. There are a couple of other HAMP-related issues that I think you should have in mind. And let me just point out on page 9, point number 9, that even if somebody is not eligible for HAMP, there is a requirement in the HAMP directives that you got to be considered for other alternatives to foreclosure. So as Peter and Eileen were just saying, there are lots of other options other than HAMP modification, but the HAMP guidelines require that the servicer consider those. So you could ask, if your client's servicer seems to be just steamrolling through to foreclosure, in discovery, what have you considered in foreclosure alternatives? Point 11, what I call HAMP for heirs. I've had a lot of cases where the person who now owns the house is not the person who signed the mortgage originally. That person has passed away, and I now am dealing with the wife, the daughter, the son, the grandson of the original owner of the house. HAMP, in my reading, has an opening. I can't say that it's clear, 100% clear in the text of the HAMP guidelines and directives that the mortgage company must allow the heir to assume the mortgage and then modify it under HAMP. But the language is open to that. It specifically refers to the situation where a borrower and or co-borrower have died, and then the person who is the representative has the authority to sign the papers. That's the only reference I've seen to the situation where the original mortgagor has passed away. There is another federal statute that prohibits a mortgage company, and it's cited in these materials, prohibits a mortgage company from enforcing a due on transfer clause. And there's a clause in just about every mortgage that if you transfer the property, the mortgage company can call the mortgage in. They're not required to deal with the person you've now transferred the house to. But there's a federal statute that prohibits that if the transfer was the result of the owner, the mortgagor, passing away, and now the house has passed on to heirs. So now it's not the exact same situation, because what you're asking for is a loan modification. So there's not an explicit requirement that the mortgage company allow a loan modification for an heir. But our position is that the refusal to give a modification that would be otherwise required if you were dealing with the original mortgagor is enough like enforcing a due on sale clause, that between this statute prohibiting enforcing due on sale clause against heirs and the HAMP requirement that a modification has to be done if the person is eligible, that putting those two together adds up to a compelling case that the mortgage company must do the HAMP modification for the heir. And that's, again, that's cited in the materials here if you want to think through that.
Let me just add that HAMP is new enough that we're not familiar with reported decisions
Yeah.
on any of the stuff we're talking about, and we're all this is all sort of the beginning stages of litigating these issues. I guess we'll see in the coming year how this stuff pans out, hopefully well.
Okay, so we're gonna move on to this issue of who owns a loan, which is clearly at this point gonna overlap into the next session.
Which, right. And because, oh, good, that's good, because actually I was, whether or not we had enough time in this session, I decided I would write a fable that I would like to present to everybody here, that I decided to entitle Mortgages, Notes, and Assignments, Oh My. Once upon a time, a very, very long time ago, people all over the country bought homes in which to live and raise their families. And in the beginning, banks and mortgage lenders created loans which enabled homeowners to obtain the funds necessary to purchase their homes. And in the beginning, these loans were evidenced by documents called notes and mortgages. And all was well and very, very good. And then came a time, however, not so very long ago, when a number of homeowners began to default on their mortgages and the sums due on the notes received by the mortgages, required by the mortgages. And the lenders would file lawsuits against the homeowners to foreclose against the property from which the loan was issued. And the homeowners asked lawyers, and particularly legal services lawyers, for help. And the lawsuits then would be somewhat simple. There would be lender, Chase Manhattan Bank versus Jane and John Doe, the lender versus the borrower. And the legal services lawyers would assert clever, creative, and substantive legal defenses to the foreclosure lawsuits. And the judges would listen, nod their heads, and seem as though they were very interested in what the clever legal services lawyers were talking about. But at the end of those arguments, the judges would ask one question. Well, does the defendant owe the money on the mortgage? And when the lawyer, honest as always, would answer truthfully, the judge would say, too bad, sorry, Charlie, and the foreclosure judgment would be entered. And all was not very well, and all was not very good. And the legal aid lawyers would shake their heads and stomp their feet, and, if possible, file bankruptcies to prevent the loss of the homeowner's residence. And once in a while, sometimes the legal services lawyers would be able to close their files with memos saying the homeowners lived happily ever after. But then, once upon a time, even more recently, the rich got richer, very, very much richer, and the greedy got greedier, much, much greedier. And people all over the country believed, except for the legal services lawyers, that everyone could afford to buy anything they wanted. And many people started buying more and more, and the notes and the mortgages got more and more complicated. And the borrowers started selling their mortgages and notes to other companies until things became really, really, really goofy. And things were not so good and well anymore. And more homeowners were having a lot of trouble in figuring out what these companies were and what the transfers of mortgages and assignments were. For instance, when people got lawsuits that said Wells Fargo, N.A., as trustee for the MLMI Trust Series 2005-FF6, care of Wilshire Credit Corporation, nobody knew what that meant. And then they started getting complaints with this sort of a caption: Wells Fargo Bank, N.A., for the benefit of the certificate holders asset-backed securities corporation home equity loan trust series WMC 2005-HE5 asset-backed pass-through certificates series WMC 2005-HE5. The lawyers and even the judges would say nobody in the whole world would know what that meant, much less the people who wrote that caption. And things were really, really, really bad. But then as the legal services lawyers started figuring out what they could do to raise creative defenses, substantive defenses to those sorts of lawsuits, and as judges started realizing that more and more of these impossibly these lawsuits in which it was impossible to understand who the plaintiffs were coming before them, a funny thing happened, and things got a little bit better. The judges started nodding their heads and saying, oh yeah, this does sound goofy to me. And the legal services lawyers started, in fact, winning some cases. And now the legal services lawyers especially have created a body of law that have raised issues in which the question of who these plaintiffs are have risen to the surface, and judges have started to take these issues seriously, not always, but we have been able to finally address these kinds of questions, which took us quite a long time to figure out as well. And but now at least we're being able to raise these issues in a way that could protect our clients' rights. And so we get back to the question then, not to say that we're going to live happily ever after by virtue of these arguments, but at least finally judges in many areas around the country are looking to these cases and looking to the arguments that are being raised and saying, oh yeah, there's merit to them, and we recognize that there's a lot of abuse in the system, so let's explore some of them. Since somebody, you asked earlier about where information can be found about these kinds of issues, about who is the plaintiff, who owns the note, because then I'll say that there are a couple of articles which I think, I don't know if you put on the CD, but I know you might have put in the materials. There's an article called where's the who owns the note, and where's the note and who's the holder, by a couple of bankruptcy court judges. And there's also an article, actually NCLC had one of their newsletters has a really good article about that.
These materials are on the disc. They're not on the paper that you have today, but they are on the disc.
And then the bankruptcy guru, who's not a legal services lawyer, he's a very well-to-do lawyer, called Max Gardner, he's recently written an article as well about what the securitization issues are, which actually, we'll deal with that too. Okay, so primarily the lawyers are starting to raise, and the judges are paying attention to the question of whether or not the plaintiff, this gobbledygook plaintiff, or even a plaintiff that you can read the name of, are the proper parties to file a lawsuit for foreclosure. The fact is that if the proper the argument is that if the proper party, the party who files the lawsuit, does not actually have the legal authority by virtue of two things: one, whether or not the party owns the note, owns the mortgage, or has been properly assigned the mortgage, and also owns or possesses the note, the loan document pursuant to which a mortgage is subsequently issued, then that party cannot legally proceed in a foreclosure action. And in a number of cases, because of the way that all of these mortgages have been sold and transferred and securitized into pools of mortgages, the plaintiff would, where the plaintiff would have the legal responsibility to prove that they are the proper plaintiff, cannot prove it. Were you trying to say something?
Well, this issue takes us back to the basic principles of the UCC for transfer of negotiable instruments. And I don't think I even had that class in law school. And as I try to read the UCC these days, I find myself just as confused by it as I would have been in my second year of law school. But it does take us back there, because each of these mortgage transactions involves a note, the actual debt instrument, which is a negotiable instrument, and the mortgage, which is a security instrument. So, in both the sections of the UCC on the transfer of negotiable instruments and security instruments comes into play. And I may be taking a little bit of a detour from what
No, I
you
was
were.
about to, go
Okay,
ahead.
so then I'll.
Go ahead.
But what happened in the securitization of mortgage loans is that there was an originator of the loan, and let's say in one of the cases that Eileen mentioned, the caption is Wells Fargo, blah, 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 blah. So let's say that Wells Fargo originated the loan. That loan was originated under a contract that already existed called a pooling and servicing agreement, where Wells Fargo agreed with one of the Wall Street banks to originate loans that would then be immediately sold into a trust. And then that trust would become the legal owner of all of these loans, but the equitable ownership, the right to the stream of payments, would belong to people and companies that bought shares, bought bonds, really, shares in bond holdings that would give them the right to the stream of payments. So the beginning point is a Wells Fargo loan, the ending point is a trust, but in between, the Wall Street banks, the people who set these vehicles up, created two other stopping points in between. My understanding is that the goal was to make sure that the trust that now has the legal ownership of the loans at the end would be remote from any kind of lawsuits that could be brought against the originator. Whether that's the homeowner that believes that some kind of wrong was done and sues Wells Fargo, but Wells Fargo doesn't officially own the loan anymore, so it can't reach the party that's able to collect the debt. And if Wells Fargo files bankruptcy, the trust is now removed, is what they call bankruptcy remote from the originator. So they made it complicated in order to protect themselves.
Can I just interrupt for a second? Last night I was actually catching up on some of my newspaper reading, and in the New York Times this past Sunday, there's actually a nice little half-page explanation of this stuff with some nice pictures that actually makes it a little bit understandable. It's on page 10 of which section of the New York City section of the New York Times. So you can, I'm sure, get this online for a while now. It's a good summary of this stuff.
Oh, yeah.
So just to spend one more minute, I'll spend one more minute and then turn it back over to Eileen. That step one, Wells Fargo originates the loan. Wells Fargo is named as the payee in the note and is named as the mortgagee in the mortgage. And there's a company called Mears, which complicates things even further, but let's just stick with the Wells Fargo example. The pooling and servicing agreement says that Wells Fargo, the originator, is going to immediately turn around and sell it to another corporation that was a special purpose vehicle that was set up for no other reason than to be this intermediary between the originator and the trust. And then there's one other party that's called the depositor, typically, which is yet another vehicle that was set up specifically to receive ownership of these loans very temporarily and then transfer them into the trust. So usually you don't have Wells Fargo to the trust behind the scenes. You have Wells Fargo A to B to C to D, D being the trust. Well, officially, you should have then a transfer of the note and mortgage at each step along the way, A to B to C to D. Now, in Pennsylvania, the rules of procedure don't require the pleading of anything about the note. But under the UCC, really the mortgage follows the note. The security instrument goes wherever the debt goes. But what you will see often in Pennsylvania foreclosures is an assignment of mortgage from Wells Fargo to the trust, this gobbledygook plaintiff that's described in the caption. But we know that there have been two other steps in between. And I'll turn it back to Eileen to talk in more detail about that and how to get at that issue in any particular foreclosure.
No, because Beth will talk about that, but but I actually wanted to start at the simplest, but by the way, there's a lot of, I know we have no time, but the simplest way to try to litigate one of these issues, not that kind of an issue, but the simplest kind of problem that you could find pretty easily is looking at when you get a foreclosure complaint, and in it, because the rules of foreclosure, as Beth said, does not say anything at all about notes, which are, however, important because of the UCC requirement and also what notes do. Without a note, you can't have a mortgage. But anyway, in the complaint will normally say, lender lent the money on such and such a date, as they're required to do. 1147 of the Rules of Procedure says what you have to say in a foreclosure complaint. Then it will say, most of the time, except for Phelan and Hallinan, the law firm of Phelan and Hallinan, will say, then there were these assignments, or there was an assignment, and it will say the date of the assignment most of the time, and it will also say where that assignment is recorded. The first step, and if there were other assignments, those should have been alleged as well. The first step in figuring out whether it's the proper plaintiff is looking at those documents. And the way you have to look at those documents is you have to go to if you're lucky in Allegheny County, you can go on the computer. I don't know about other places. Many of you will have to go directly to the Recorder of Deeds office to look at those documents, because typically if they're recorded, they will not be attached to the complaint. As Phelan sometimes says, we're in the process of recording, or we're in the process of formalizing the assignment and it's not yet recorded, but they haven't attached it to the complaint, then the first thing that any litigator should do is file preliminary objections to request, to say that that document is a document which is necessary to prove the case, it's not attached, and therefore they must either attach it or identify where it is in the public records. So look at the assignment, and what do you do when you look at the assignment? Look at the mortgage, look at the assignment, and then see whether or not, first of all, whether or not the assignment says that the lender actually assigned it to the plaintiff. And if it says yes, and if it shows that there's an assignment to the plaintiff, okay, then so far so good. Then you look to see what date the assignment was made from the lender to the plaintiff. And if the date on which the assignment was made is after the date of the filing of the lawsuit, then there is a legally objectionable plaintiff, because the law of filing lawsuits in Pennsylvania requires that on the date that a lawsuit is filed, the cause of action must exist. And if the plaintiff is not a proper plaintiff on the day that the lawsuit is filed, because they didn't have the assignment on that day, then there is no proper cause of action. There's cases that have nothing to do with foreclosures which says that. So what would then happen is, if you see that an assignment was filed, was prepared, was written after the date of the filing of the lawsuit, you can then file an answer saying that the plaintiff is not a proper plaintiff, that there is no cause of action properly filed by this particular plaintiff, and the case should be dismissed. That's number one.
That we're gonna need to pick up, there's another group that's
Oh.
presenting right now.
Here?
Here. If I'm, we're back in another hour, I think. I think it's they're
Oh,
presenting on
boy.
tenants, rights in foreclosure, so I think we're gonna have
To
to
be
pick up on this.
continued. I can't believe it.
Sorry.
No, it's okay.
We'll pick up right back here.